To the order of reference of Wednesday, June 5th, 2024, the committee is resuming consideration of Bill C-61, an act respecting water, source water, drinking water, wastewater, and related infrastructure on First Nation lands. I would like to welcome our witnesses for our first panel. From the Assembly of First Nations, National Chief Cindy Woodhouse Nepinak. Alongside her is Christopher Rapson, Legal Counsel, and Irving LeBlanc, the former Director of Infrastructure and Safe Drinking Water. From the Assembly of Manitoba Chiefs, we have Chief Betsy Kennedy, Acting Grand Chief, who's joining us by video conference. From Cold Lake First Nations, Chief Kelsey Jacko. And from the Kehewin Cree Nation, Chief Trevor John. So welcome, everybody. With that, you will each have 5 minutes for your opening statements, after which we will proceed with the rounds of questions. And we will start with the National Chief, Cindy Woodhouse.
Mr. Chair. Something a little bit different because it is my first committee appearance as National Chief, and I'm going to ask for a couple of extra minutes for your time. And I know Creator gives us life today, all of us, to live, to breathe, and He's the one who provides us clean drinking water and clean source water. And I'm going to ask, I know Chief Kennedy's on the line, if I can please ask Chief Kennedy to start us off in a good way. Pray for this day for all of us, for our families. Thanksgiving is coming. And I'd like to ask her for that. I know that this is an important issue, but I ask for your time as we stand and we thank somebody above that's above us that helps us to be here today. Chief Kennedy?
Good morning. Thank you, National Chief. Thank you for this day, as it is really nice, and that our Creator is here to bring us together to save our communities, and that we are here to protect the lands that we live and continue with the help of our Creator, and that we ourselves help in preserving and continuing to do all that we can on Turtle Island. And we ask you to protect and to help us, guide us in what we need to do and for our children and for our future. I'll say that and amen. Like I said.
Kennedy. Jimmy, go ahead to Chief Kennedy. Can you hear me okay? We're good? It's so nice to see each and every one of you. For those of you that don't know me, I grew up on a small First Nation in Manitoba, about 2.5 hours drive from Winnipeg. And before we go on, though, I also want to acknowledge a colleague of mine that has since passed. Since we haven't met, but we're meeting for the first time today. So I thank you for all your work. But I want to acknowledge Grand Chief Merrick, and I want to thank Chief Kennedy for playing an important role during this transition time back at home. I also want to thank chiefs here for joining me, and colleagues and my staff from the Assembly of First Nations. I am the National Chief for the Assembly of First Nations, and I've been so for the last 10 months, and I look forward to working with all of you for the 3 years ahead, full 3 years ahead. I want to acknowledge that we are gathered here on the traditional, unceded, unsurrendered territory of the Algonquin people. I would also like to thank the committee for inviting me to speak on Bill C-61 on behalf of the Assembly of First Nations. The Assembly of First Nations has long advocated for funding and resources to address the water crises affecting First Nations. Historically, the federal government has failed First Nations by chronically underfunding drinking water and wastewater services, as well as implementing programs that have ignored First Nations rights and autonomy. On June 5th, the city of Calgary experienced a water main break leading to a boil water advisory and conservation measures that dominated national headlines. This is in stark contrast with the media coverage of First Nations drinking water issues that have existed for decades. Compared to other Canadians, First Nations living on reserve are 90 times more likely to lack access to running water. For the past 3 decades, there have consistently been at least 100 long-term and short-term advisories in First Nations, with 30 long-term advisories still in effect. Excuse me. First Nations do not receive the same level of water and wastewater services as the general Canadian population. Bill C-61 presents a significant opportunity to address this long-standing injustice. The Assembly of First Nations is confident that the proposed legislation before this committee addresses one of our most critical priorities: ensuring safe and clean drinking water and adequate wastewater services for First Nation citizens. It is designed to address the long-standing water crises in First Nations communities across Canada and ensure meaningful change. The Assembly of First Nations has worked diligently to ensure the legislation contains the necessary minimum requirements as articulated by First Nations. The royal assent of Bill C-61 is a critical opportunity to address the issue and ensure First Nations have access to adequate drinking water and wastewater services and programs that respects their needs, rights, and self-determination. Bill C-61 was jointly discussed and developed between Indigenous Services Canada and the Assembly of First Nations. And I commend people like Joanne Wilkinson, Phil Fontaine, Chief Linda DeBossegay, who over few Christmases ago, over Christmas, everybody was resting, and they were there getting down to the work of this. So I lift them up in a good way. As well as, of course, we've got Irvin LeBlanc beside me. I thank you for your hard work and dedication to our people for many, many years. It marks a significant step forward in the recognition of the inherent rights of First Nations and their jurisdiction over critical matters. The current version of the proposed legislation has significant improvements to previous versions, and it reflects progress in addressing the critical components that were identified by the Assembly of First Nations during engagements held from 2019 to 2023. The proposed legislation provides recognition of First Nations' inherent right to self-government over source water. The Assembly of First Nations consistently advocated for the inclusion of source water protection that recognizes First Nations' inherent right to self-government over drinking water, wastewater, and associated infrastructure. We understand that a source-to-tap protection is the safest, most efficient, effective, accepted, and cost-effective approach to manage drinking water long-term. The proposed legislation has made efforts to address long-standing funding issues. Currently, funding to support the provision of water and wastewater services is determined through a fully discretionary approach by the Minister. Although we understand that including statutory funding transfers under the legislation would have provided assurances to First Nations, the proposed legislation commits to developing a funding mechanism in collaboration with First Nations for direct and long-term funding. Under this legislation, the Minister must consult and cooperate with First Nations to develop a funding framework that provides adequate funding and meets the actual cost needs of First Nations and ensures comparability with non-Indigenous communities. Strong wording will continue to protect First Nations and ensure that they receive the necessary funding they require for years to come. The proposed legislation includes important sections on standards. First Nations are entitled to water quality, water quantity, and wastewater effluent standards that meet or exceed the highest standards of other relevant Canadian jurisdictions to address the current federal regulatory void. Based on engagements held from 2019 to 23, the proposed legislation now specifies the standards applicable for water quality, quantity, and wastewater effluent for both public and private systems, based on assessment of all existing and potential future needs. It must protect and provides opportunity for First Nations to develop their own standards and address all their water needs from domestic to institutional, commercial, and industrial demands that help First Nations grow. This is an important inclusion of First Nations governance resources and support in the proposed legislation. This includes a commitment to establishing a First Nations Water Commission to support the purpose and principles of the legislation. Under the legislation, the Minister will consult and cooperate with First Nations on the development of a terms of reference, a defined period for co-development, and a commitment to funding. It enables the creation of a First Nations governance institutions, which must be led by First Nations in their own ways and at their own pace. There is an important mechanism for transboundary agreement making. Although the Assembly of First Nations did not co-develop the language for the sections related to the protection zones, through its advocacy, the proposed legislation includes a provision for transboundary source water agreements, ensuring First Nations are involved in all agreements that affect them. Protecting source water that are often located off reserve is critical. These areas are within the traditional and ancestral territories of First Nations, where provinces and territories have extensive jurisdiction. Addressing on-reserve waters alone is insufficient. Source waters that provide drinking water for First Nations must also be protected. A key concern raised by First Nations is immunity and liability. The proposed legislation states that no employee or person hired by a First Nation can be held liable if they acted in good faith in their duties in the provision of water and wastewater services. A First Nation may still be held liable, and it's important to recognize that sufficient funding goes hand in hand with accepting liability. No First Nation is prepared to accept liability for an underfunded system. The Assembly of First Nations is committed to defending against amendments that would diminish or otherwise weaken the proposed legislation. We must ensure this legislation is as strong as it can be, and to that end, we are advancing amendments to improve the bill on protection zones, 2, standards such as the requirement that quantity of water would meet all needs, including agriculture, fire protection, industrial, commercial, etc. 3, the funding framework. 4, the First Nations Water Commission. 5, liability, immunity, and indemnification. And lastly, and references to best efforts. Details of these amendments are contained in our written submission, which has been provided to this committee. Currently, without legislation in place, there are no enforceable standards or regulations, no recognitions of rights to govern water and wastewater on First Nations land, and no sustainable long-term funding mechanism. Comprehensive legislation compliant with UNDRIP will further Canada's commitment to reconciliation. The urgency of this issue has stated for decades. Now it's the time to act. In closing, Canada recognizes the human right to drinking water and sanitation and has obligations to all First Nations. This is an important moment for Canada and for First Nations. We look forward and we look to you for your support in moving this forward in a good way. So I just want to say Chimigwech for this very important matter, and thank you for your time on this. It's an important moment for all of us. So thank you, Miigwech, for welcoming me here today.
Thank you very much, National Chief. Next, in the opening statements, we will turn the floor over to Acting Grand Chief, Chief Betsy Kennedy from the Assembly of Manitoba Chiefs. Chief, you have 5 minutes or less for your opening remarks.
Good morning. Thank you. I want to thank the Standing Committee on Indigenous and Northern Affairs for the opportunity to speak with you today on Bill C-61. I am Chief of War Lake First Nation and appearing before you acting as the Acting Grand Chief of the Assembly of Manitoba Chiefs. I would like to begin my remarks by explaining the significance of water crisis for our First Nations in Manitoba. As we all know, lack of access to drinking water has devastating effects on our health. Some, however, may be less familiar with the host of the adverse effects of well-being. Many of our children that live in these First Nations without proper drinking water and proper water they are very sick and they develop conditions that they have to seek help every day in their lives, and sometimes it does go right into their till they become adults, and this is very stressful on families because they don't know who to turn to sometimes, and I have seen it and been with my own family going through the same thing that are in First Nations that have boil water advisories. I want to state also that we support Shamattawa and their concerns with the drinking water, and that we should have access to to drinking water as everyone else that has drinking water across Canada, and that we have this legal right to be able to have the the right to be there, to have access to clean drinking water, and to have water in every First Nation across Canada. Important teachings and knowledge that should have been passed down over generations have been disrupted. These losses have created disconnect between First Nations and the land, a relationship that is fundamental to our worldview. The result impacts of well-being, spirituality, and concepts of identity cannot be overstated. On the foundation of this knowledge, I want to express concerns on how this bill impacts First Nations' right to self-determination. The bill follows a similar framework to existing Canadian laws, which limits the recognitions of First Nations' inherent right to self-government through the delegative approach. In short, Parliament is telling First Nations how they enact laws, though their inherent jurisdictions subordinating First Nations governments and undermining the nation-to-nation relationship. The AMC rejects the notion that First Nations jurisdiction and lawmaking authority is contingent on federal legislation. One nation cannot control or validate the other in a true nation-to-nation relationship. It requires equal recognition of the laws and authority of the other. Also concerning is the fact that the bill only recognizes First Nations jurisdiction on First Nations land. If the water is stagnant and as if the water is stagnant and does not flow from one jurisdiction to another. I want to emphasize National Chief in saying that we have the water runs in many directions, and it goes to and the water flows are in many directions, and that it's not just on First Nations, but the water that we have live off is off reserve, but we utilize as First Nations the water, the spring waters that are in the areas, and those are the waters that we have want to protect also. Also concerning is the fact that the bill only recognizes First. As a result, there is no recognition of First Nations jurisdiction on much of the treaty and ancestral territories of First Nations in Manitoba. Overall, the proposed act fails to fully recognize First Nations jurisdiction and conveys the lack of respect of our laws. It only recognizes First Nations authority over water resources within the confines of First Nations land, despite the fact that the water knows no boundaries. When we see buildings or roads being built, they don't meet with the First Nations because we know where these waters are, the wells that are been there for a long time. they're just being bulldozed. And those are the waters that we would like to protect. Those are the waters that are the clean, and that some of these waters are not just for drinking, but there are minerals in there that do help in the way of medicine. So in order for us to protect the water, we would like to include in Bill C-61 water protection is that it's not just within our communities on reserve that we're protecting, but it's also the waters that run outside, and the water is all over, and that we would like to protect that. And there's a lot of industries that are going, and that's the reason why many of us are going through these issues with health, and with the issues of health, it really undermines when we try to do what we can to protect our children and grandchildren with some of these diseases that needs attention. The doctors do.
Chief, I'm very sorry that I need to do this. We are running over time for the
Okay.
opening remarks. There is going to be time once we get into the rounds of questioning, and we'll be able
Thank
to
you.
hold that thought and get back to it then. Sorry that I do need to do this, but we will turn it over next to Chief Kelsey Jacko from the Cold Lake First Nations for 5 minutes or less for an opening statement.
Good morning. I am Chief Kelsey Jacko of Cold Lake First Nations. Thank you for taking the time to listen today. And thank you to Chief Cindy Woodhouse for helping to make this happen. You have our written technical statements, but today I want to speak from the heart. I want to acknowledge we meet today on the lands of the Algonquin people who have been and still are care and stewards of the land. In my culture, as with all peoples who are connected to the land, water is life. Before we're even born, we are in water inside our mother's womb. Thui Chuktuwe and Hatuwe have been the womb my relations have centered their lives around from time immemorial. The people moved with the seasons to Hatuwe for a trapping and winter camp, and Thui Chuktuwe for the summer months. Our treaty practices depend on these waters. In treaty, the phrase, "as long as the river flows," is about my people's ability to continue living and bringing forward new generations. It's also life for our fish, our animals, birds, and bugs. We understand your objective with the water legislation, and we agree that source water protection is key. The issue is that legislation provides no real tools. It is more of a suggestion than legislation. My nation is fortunate to have much lower industry and agricultural allocations than the volumes impacted most nations. Still, as the Indigenous population grows, we will be last in line for water, even though we've been here long before Europeans could even find this continent. Unless something changes, our concerns will always be last in line when it comes to water. The historical unwillingness of Canada to fund on-reserve water infrastructure has put most nations in the position of being last in line. Under Alberta's first in time, first in right legislation. Other provinces have similar legislations, and until our inherent rights are recognized within the legislation frameworks, our communities are at risk. In Alberta, we have a lot of problems with water as our growing population demands more and the land gets drier. Will the North Saskatchewan one day be like the Colorado and not reach the sea? Will our industries and cities collapse with our environment? The Bennett Dam destroyed the livelihood of our Dene cousins in Fort Chipewyan. In Treaty 7 territories, only 7% of the resources allocated to fish, wildlife, and general habitat management. In-stream requirements, the ones that sustain the critical habitats, are not well understood. To be clear, we do not know if the amount of water currently being left is enough for fish. We certainly don't know the appropriate amounts for wetlands and the aquifers that support them. And by we, I mean humanity. Today we have provinces, regulators, and industry working to release oil sands water into the river, or releasing it by accident. And they're lying about it, as with Curl. We know Canada is working with industry on slow release, but this isn't the way. They said they could clean it, and they should. Instead, Instead, they hold it hostage. In my area, we see our water lines being built to suck large volumes of water out of our lake for industrial and domestic use. This year, the lake was so low that the water withdrawals had to be suspended, and the place where our kids learned to kayak and canoe had 50 meters more beach. This means industry just switches to groundwater, but these aquifers have fallen as much as 30 meters because of oil sands use. The AER lets companies pollute shallow groundwater so as long as it stays on lease. These companies can just leave, but my people will be here forever, bringing forward new generations. The watersheds we depend on flows right through Cold Lake Air Weapons Range, draining from Alberta and Saskatchewan. So we will have to deal with 3 governments. And I will say that both DND and Saskatchewan have both been supportive efforts to expand protection of the land base. Parks Canada is working with us on creating an ecological corridor that will protect the largest river flowing into our lake. But generally, we know that climate change is going to bring more low water years, and no one seems interested in the kind of monitoring and management required for sustainability. We acknowledge that the legislation is a sincere attempt to move forward on a complicated issue, but we need to see it provide more actionable solutions, tools that we can use. At the regulatory level, the majority of the consideration surrounding water is for use. Consideration for the environmental impacts of lowered water tables and in-stream availability comes dead last. This is not a way to uphold treaty. CFLN belongs to a regional utility board that is a partnership between my nation and our immediate neighbors. Many of these neighbors draw their water from Cold Lake. We are doing our best to work together to manage local resources. However, Alberta won't even share the key performance indicators it uses to ensure that water allocations are sustainable. The Alberta government has demonstrated they are unwilling to enforce water rationing on industry, even in times of crisis. What makes Canada think they will work with us on prevention? Industry oversight is mostly reliant on self-reported statistics, and as we have seen recently with methane release, these numbers are unfortunately rarely reliable. Because of the importance of the land and our treaty rights to all treaty peoples, putting source water protection into the hands of the nations will help to address the principal agent problem most governments face. My understanding of the intent of this bill is that its purpose is to give nations clear tools with which to uphold their inherent rights to water. However, the current version of the bill contains no material recognition of these rights, and instead it reads like a joint venture option. You have to understand the nations never gave up their right to care for the water. This is what we mean by inherent rights. The concept of owning water at the time of treaty was like saying you owned the stars. It is an outrageous impossibility. Canadian law already recognizes this concept. You sell the right to access, move, use, and pollute, but not the water itself. If you are serious about protecting source water and acknowledging the inherent rights and responsibility of First Nations as protectors, I ask that you consider what the bill offers on the ground for our technicians, particularly for those nations that are being asked to partner with unwilling provincial governments or who will be forced into a four-way partnership as CLFN would. If your goal is to be good treaty partners rather than asking province to cooperate, you need to recognize the interjurisdictional nature of this resource and employ the jurisdiction space available to you in this bill. Masi Cho, and thank you for your time.
Thank you very much, Chief Kelsey Jacko, and we will move to our fourth and final opening statement from Chief Trevor John. You have 5 minutes or less.
Thank you. First and foremost, I'd like to thank the Creator for blessing us all with a beautiful day and this time together. I would like to thank our National Chief, Cindy Woodhouse Nepinak, for helping us get this time together with all you folks. And I'd like to thank the Elder for blessing us with a prayer this morning. It's always good to start out with a prayer in our culture, so hi to our Elder, Betsy. For those of you that don't know me, my name is Chief Trevor John. I'm from Kehewin Cree Nation, Treaty Number 6, Alberta Region. Danse, bonjour, and hello. Kehewin Cree Nation, like many of our neighboring Cree tribes, sits near a water source. This is no mistake. Our ancestors at treaty time, along with the Dominion of Canada officials, marked out spaces that the Indian Act calls reserves. Where our people would have access to basic human right of safe drinking water. The treaties themselves are referred to last in perpetuity, for as long as the sun shines, the grass grows, and yes, the waters flow. Canada has a lasting obligation under this relationship created by treaty to ensure that Treaty First Nations are supported as far as water and related infrastructure. This bill attempts to abandon all of this in favor of Section 35 rights of self-determination. This is wrong, shameful, and unethical. And yet here we are in 2024 with exactly that. It must be said that the preamble of Bill C-31 has good-sounding words, all the right language about reconciliation and recognition. Sounds good on the surface, but it doesn't bind Canada or Alberta to ensure that the long-standing issue does what the intent of the preamble is, that it is to ensure safe and viable water and water infrastructure beyond best efforts. If this bill goes forward, we feel that it will not be linked to treaty-based implementation, planning objectives, or milestones. Bill C-61 looks like lip services to a nice future, but does not meet the reality we have with the province of Alberta. This bill does not guarantee that Alberta, and based on our extensive experience with Alberta, there is no current recognition or relationship that enables us to ensure our peoples have sustainable infrastructure. C-61 says, an act regarding water, source water, wastewater, and related infrastructure on First Nation lands. Inside the bill, it says, in, on, and under the First Nations lands. Jurisdiction under treaty means the whole of the treaty territory, and for many of our nation that goes well beyond provincial lines where our reserves are designated. This is what needs reconciliation if the bill is to mean anything. Canada's Declaration action states a commitment to honorably implement historic and modern treaties consistent with Article 37 of the United Nations Declaration. Bill C-61 in Canada's processes to discuss it needs to work on it through this. As a chief of my nation, this is not honorable on the UN Declaration commitment, and this bill will, like those that came before it, will fail us. Bill C-61 provides Treaty First Nations with no assurance for improving water health and meeting current or growing water infrastructure needs. It contains significant loopholes for Canada to delay implementation and decisions on commitments to providing funding for addressing long-standing needs. It does not contemplate binding obligations to ensure adequate or consistent resourcing for needs and how those real needs could change over time considering climate change and other related impacts. The bill says Canada will use best efforts to ensure access to clean and safe drinking water on reserves. But this is not binding, with no clear implementation plan that considers actual and full costs according to those needs. Then we are setting the stage for new challenges for the next generations, and this is not acceptable. Canada often talks about a whole government approach in relation to reconciliation. On water, the potential of this is something that could be supported of a treaty bilateral approach. But instead, Canada this summer, through an order in council, gave permission to Alberta, Saskatchewan, and Manitoba provincial governments to reapportion water for their purposes without a single interaction with our governments. This is not a good start for us to feel any assurance that best efforts language will help us as our needs for water and related infrastructure will be prioritized. Since 2019, Canada has indicated it would be gradually transferring all programs and services to willing First Nations. They are using comparability standards that is provincial standards, and in implementation of the transfer of responsibility, and are calling that self-determination. It seems to us as treaty leaders that Canada through ISK is trying to do is to leave its legal obligation because they know what we know, because we have told them that the infrastructure gap in our nations is much larger than what AFN has told them. So today I'm asking on behalf of my peoples is that Canada gets real and works with us to address the actual needs it's responsible for under treaty. As we have told the ministers, treaty means good faith dealing to address the actual water and infrastructure needs of the nations and ensure Bill C-61 is amended to address those needs as promised under the treaty relationship. Acceptama, hi hi.
Very much, Chief. With that, we are going to go into our first round of questions. I am going to be reducing a little bit because I do want to get a chance to go through 2 rounds. So we'll go for 5 minutes for each of for the first round here. So starting with the Conservative Party and Mr. Malil, you have 5 minutes.
Chair, and I want to thank all of the individuals for joining us to talk about this important legislation. I do want to talk I do want to start by also offering my condolences to Chief Kennedy on the passing of Grand Chief Merrick. I know it came as a shock for many people right across the country, including myself. I was actually planning to meet with her just around that time, so it came as quite a shock. And I want to thank you for your work here in the interim, for being here to ensure that the Assembly of Manitoba Chiefs does have a voice during this important discussion. And I'll start with you, if I can, Chief Kennedy. I'm curious if you can describe the Assembly of Manitoba Chiefs' involvement during the consultation process and the development of this bill.
Chief Kennedy, just you'll have to move your microphone down there so we can hear you. Thank you.
Thank you. AMC developed a proposed draft of First Nations water strategy in 2013 through a process that enabled First Nations in Manitoba to come together and express their views and share their knowledge. This draft outlines key issues and actions related to water rights, access, protection, and management that could be built upon the context of Bill C-61. Thank you.
Thank you very much. I appreciate that. And I want to ask National Chief, we've heard from officials at ISC and witnesses here at the committee that the government has incorporated direct feedback from First Nations in the development of this bill. Can you give any examples of direct feedback from AFN that has been incorporated into C-61?
For that, please, because they went through the notes thoroughly. Thank you.
Thank you.
Thank you, and good morning to the committee. So one of the key examples of feedback from the AFN and from First Nations that has been incorporated by the government in the draft bill is the protection of source water. That's really, I think, the key example. And that's done through a number of mechanisms, but that's really the key change, I think, from earlier drafts that reflected input from First Nations and from the Assembly of First Nations.
I appreciate that as well. Thank you. And I do want to come back to National Chief or whoever will be answering, because you did mention some amendments and one around protection zones as well. And I know that there is a brief, but for the committee and for those who may be watching, would you be able to describe in more detail what the amendment around protection zones will be coming from AFN?
I'm sorry, couldn't quite pick that up, Mr. Mano.
There was an amendment the National Chief alluded to pertaining to protection zones, and I'm wondering if you could speak to that amendment, proposed amendment.
Fortunately, I had left already the AFN when those amendments were made. I will refer to my colleague here on those amendments. Sorry.
Yeah, thank you, and thank you for the question. This is one of the key amendments that the AFN is putting forward with respect to the bill. And looking at protection zones, the draft as it stands only partially recognizes First Nation and affirms First Nation jurisdiction over source water off reserve. In fact, it makes that recognition and affirmation contingent on First Nations reaching agreements with provincial and federal territorial governments. Now, as you've heard from other witnesses, that jurisdiction, the inherent jurisdiction of First Nations to protect their source waters, is not contingent. It's not contingent on federal legislation, this bill or any other legislation. It's not contingent on those First Nations reaching agreement. So the amendments that we're putting forward is to fully recognize that jurisdiction. And one of the mechanisms for doing that we're putting forward is looking at a mechanism that's already been tested and endorsed by the Supreme Court of Canada, and that is the mechanism in what's referred to as Bill C-92, or an act respecting First Nations, Inuit, and Métis children, youth, and families. That mechanism, we think, would do justice to the First Nations with respect to the recognition and affirmation of their inherent jurisdiction over source waters and protecting those source waters.
We'll next move to our second questioner here. Mr. Carr, you have 5 minutes.
Thank you very much, Mr. Chair. I want to begin just briefly on two personal notes, echo some sentiments that have been shared already. So to Grand Chief Kennedy, it's a pleasure to be with you here this morning. As the sole Manitoba representative around the table, I can certainly share the feelings of many in Parliament and across the province in our grief and shock about the passing of Chief Merrick, but very much looking forward to working with you and continuing the legacy and the path and vision that she set forward as you undertake these important responsibilities as Grand Chief of the AMC. Chief Woodhouse, this is a special moment for me because you and I have known each other since we were 15 years old. And I have seen you work hard and grow into an inspiring and meaningful leader. And much of my understanding of our history as it pertains to First Nations people, our public policy development, and our path toward truth and reconciliation has been informed by the mentorship and guidance and friendship that you have provided to me over the years. So to be with you in this capacity is quite special to me. I want to just take a step back, National Chief, and ask you to more broadly address, in your view, the evolution in the past number of years of where we have come on this water file. As Regional Chief, it was one that you spent a fair amount of time invested in developing, and I'm wondering if you can provide some commentary about how you have seen the evolution of our public policy around the protection of First Nations rights, particularly as it pertains to water, from your time as Regional Chief and then where we're at here today as we're talking about implementing the legislation found throughout Bill C-61. So I'll turn it to you with that.
Certainly, thank you for that, and nice to see you this morning. And I think of, I can't remember, but hold up your dad as he walked these chambers, and my heart goes out to you and your family. My sincere condolences on his passing, and I'm glad that we're sitting here together today. Nice to see you all. I just have to say that this is a very important moment for First Nations in Canada. I know that there was an old bill and we're repealing it, and I know that let's not go back to the way that that bill was done in the past. It was very hurtful towards First Nations. I know co-development isn't also easy. I know we're here talking about amendments on this bill, and growing up on a First Nation community when I was a little girl, it was, I could drink easily from the water. I grew up there, And I know that we've come a long way in First Nations communities, but we haven't come far enough. And I think that watching this, the way the first piece of this done, had it been done right back then, I think we wouldn't have been sitting here today. We would have been on a different track. So we're here now, and we're here now together, and we're here to try and work towards, working towards a bill that we can agree on. And we hear from the amendments from many, many speakers before me. And I think that if we can put some of those pieces into this legislation, we'll move this along very quickly. And at the same time, I know that First Nations have never ceded their jurisdiction over their traditional waterways or source water. The United Nations General Assembly recognizes the human right to water and sanitation and the right to a clean, healthy, and sustainable environment. We don't have that right now. And so I know that legislation is a necessary tool to ensure meaningful change to the current water crisis faced by First Nations across Canada. Legislation and how it's developed is critical to the quality of life and self-determination of First Nations. The process involves more than consultation, however. It requires cooperation and working together in good faith. This is the core of co-development that speaks to a two-way collaborative process. This is the foundation of the commitment Canada has made through Section 5 of the Federal UN Declaration Act, UNDA, which requires the following. The proposed legislation must meet this bar, and all eyes will be upon it, to assess whether it does that and whether Canada is sincere in the commitments made in UNDA. So this is an important moment for First Nations in Canada. I know that simple things that many Canadians take for granted, we don't have that on a First Nation. I've lived in 2 First Nation communities, and in either place that I've lived, I've never had access to clean drinking water. I'm so used to drinking bottled water that it's sometimes hard when you come off reserve to have to drink this water beside me, because we're so used to drinking bottled water. And I think that that's the reality for many First Nations in this country. And I look to a time where we can fix that. It also disheartens me when I see fishermen in Lake Winnipeg, and I have to say this, First Nations fishermen in Winnipeg that are pulling up nets that are full of stuff that we have to do better in this country. The waters, it's starting to show. The animals are starting to show us that. Our people are starting to show us that. And I just look forward to working with all of you to find that path forward. And I think that this is a right step in that direction to move in a good way together. Thank you.
Thank you very much, Mr. Carr. Au prochain, on va aller à Monsieur Lemire pour 5 minutes.
Mr. Lemire for 5 minutes. Thank you, Mr. Chair. Firstly, I'd like to offer my condolences to Chief Kennedy. Chief Woodhouse, we've heard several Indigenous organizations say that they're looking for changes to strengthen the bill and to ensure that their treaty lands not be harmed or pushed back because of this act. Last July in Montreal, there was the APTN National Assembly, and I was there. To date, we haven't received the written note from the APTN stating what their suggested amendments are. Would you be able to clearly state what the requested amendments are?
Yes, thank you for the question. And with respect to the treaty rights of First Nations, again, this comes back to protection zones. We understand the bill does not at this time have a definition of protection zones. So one of the amendments that the Assembly of First Nations is putting forward is the beginnings of a definition of protection zones that would include both the traditional territory and the treaty territory of First Nations, where source waters flow from those territories to First Nation lands. And of course, there is inherent and treaty right for First Nations to protect the source waters in those territories, and so our amendment would reflect that.
Comment, selon vous, ça se coordonne avec...
In your opinion, how can this be coordinated with provinces who have the responsibility to manage water?
Thank you, National Chief. And thank you again for that question. And this comes back to the mechanism that I referred to earlier, and that's a mechanism that's already been, as I said, tested and endorsed by the Supreme Court of Canada with respect to the coordination and application of laws in places where there is overlapping jurisdiction. And so we believe that that mechanism, adapted from what was known as Bill C-92, would provide for dealing with those overlapping jurisdictions and the coordination of laws in a way that respects that First Nation jurisdiction, both inherent and treaty rights.
Et comment vous voyez des négociations?
And how do you see these negotiations when there is an overlap of waterways between multiple provinces? How do we define these protection zones? For example, there's the Kichisibi, the Ottawa River in this region, shared waterways. How can we ensure that this is protected beyond different jurisdictions?
So it is about coordination. We live in a country of cooperative federalism, and that requires that provinces, the federal government, and First Nations be at the table to discuss and negotiate where jurisdiction overlaps. Unfortunately, if one of those parties chooses not to come to the table or refuses to enter into an agreement, that can obviously stall the negotiations and leave us in a deadlock or a stalemate. That can't be allowed. We can't be frustrating First Nations jurisdiction in those circumstances. It is inherent. It does come before other jurisdictions and should be given the force of federal law, and therefore paramountcy over provincial laws where provincial governments refuse to enter into such coordination agreements.
Dans un esprit, évidemment, de dialogue.
So we're looking to have open dialogue between nations, and I would ask the AFN to make their documents available in French, because then it will be easier for French-speaking communities to be able to know what they're sharing. And of course, this is much needed in Quebec. So in the introduction of the bill, what could we add to this? I think that it's been established that we could make it stronger, for example, to recognize the importance of treaty rights and reconciliation and productive partnership.
Yeah, it's kind of hard. You're talking with the provinces. Our treaty predate the making of the provinces or whatnot, and it's about the trust. You know, like a lot of provinces are not transparent with First Nations, so we got to be a part of the monitoring. You know, to make sure the water is safe. You know, because like I said, we're last in line, and it shouldn't be like that. You know, we were here before the creation of Canada and whatnot, so it's kind of hard when you have an unwilling partner to work with, right? So a lot of the times talks go on to stalemates, or you know, just go into standstill. So it's very frustration for First Nations.
Merci beaucoup, Monsieur Lemire.
Thank you, Mr. Lemire.
We'll be going to Ms. Idlout, joining by video conference. You have 5 minutes or less.
Thank you, Chair, and thank you to all of the witnesses for appearing before our committee on such an important matter. I share the sentiments with Acting Chief Betsy Kennedy and the sudden loss that we all experienced with the loss of Chief Merrick. She had such an important role. And for you to take on this role at this urgent time is much appreciated. And thank you for sharing your testimony as well. I'm quite honestly frustrated with this committee because we've been limited in our time to ask so many witnesses. I'm frustrated with this committee that we're trying to rush through getting through as many witnesses as we can, especially knowing that out of the 634 First Nations, about 31% will be were only consulted in the development of this bill. In my eyes, this is not meeting the standard of the duty to consult. And I think that it is so important that we hear from as many witnesses as possible. We had great testimony, for example, from Chief Trevor John, who shared very clearly what the concerns are around source water, jurisdiction, sustainable infrastructure. Those things in the bill are not clear enough. It is, especially in this time when we all know that First Nations managed water with their own laws before Canada stole your jurisdiction, and for them to try to hand it back in C-61 is completely unacceptable. We need to do a better job of ensuring that First Nations treaties are being implemented, that First Nations human right to water is being upheld, and we're not seeing that in C-61. I'm going to ask very quickly to Chief Cindy Woodhouse. Nepinak, congratulations on becoming the National Chief for the Assembly of First Nations. I wanted to point to the federal court case with Shamattawa First Nations, where the federal lawyer, Scott Farlinger, was at first acknowledged that there's been a historic underinvestment in First Nations water, but also sharing his argument that, quote, everything is better now. Can you respond to that, please, Chief Woodhouse?
Oh, thank you, and thank you. Absolutely, we stand with Shamattawa. I grew up the way that I feel for the people up there, and I invite this entire committee and Canada to really look and come and visit our communities and see the reality of what our First Nations face day to day with basic human rights like access to drinking water and source water. And sometimes you go up to these communities and you come back down and you realize the disparity that many of our First Nations are facing. And so this country has a lot to answer for of what we've been through for the past 150 years. I know that that's not what, as we hear about the relationship between First Nations and the rest of this country, I'm glad that we're finally here having these really difficult discussions with each other. They're not always easy, but they're absolutely necessary, even when it comes to things like safe drinking water and sanitation. I know that there's a lot to work through, and I know that this is a really tough issue, and my heart goes out to Shamattawa First Nation. And Canada, you have to right that wrong with Shamattawa First Nation. We can't leave them hanging. And for the lawyers, for the minister, and I'm glad for her comments on water and trying to work that way. But the Department of Justice lawyers to go out and say the statements that they're making. The right hand needs to know what the left hand is doing when you're going out there and speaking to my people, speaking to First Nations. You can't say one thing on one hand and then have your lawyers coming to say something else on a legal way. So the political way, yes, okay, there's that will. I'm glad you're all here today. I commend all of you for sitting here with us. But at the same time, when your lawyers who are writing all these laws, and that's where the mistrust comes from us, is because these lawyers are there and then they go into court and they say stupid things like that to First Nations. And they make us feel like, well, I thought we were making progress. And then it's kind of hard as National Chief, you hear that the day before, and I'm glad that we're working on this legislation trying to co-develop and work through some of these pieces together. But we really have to work stronger together. Obviously, you're seeing the cracks in it even before this committee had happened this morning. And like I'd said, my heart goes out to the Shamattawa First Nation and Canada, right that wrong with them. Thank you.
Thank you so much. My next question is
Sid Louts,
to...
I'm going to have to cut you off there. Apologies to do this, but we are over time. But you will have another opportunity to ask a question. So we are going to move into the second round of questioning. I'm going to cut it in half. I just want to make sure that everybody has an opportunity to have another intervention here. I'll be going to Mr. Shields for 2.5 minutes.
Mr. Chair, and thank you for the witnesses being here, and thank you for that statement about despite the ministers publicly acknowledging federal responsibility for water crisis, they continue to support completely contrary position in court. That came from Manitoba Federation yesterday. Appreciate that. When I look at this legislation, I see the Canadian government, the provincial government, the Canadian Water Commission, and the Indigenous Water Commission. No matter what you say with this legislation, we're not going to fix the water crisis tomorrow. We're going to be in court for years. You know that. So if this legislation says we empower the government to build water treatment plants in cooperation with every nation in the country starting tomorrow, we set up regional training centers with support staff to train water treatment people that are available 24/7. If we set up a system where supplies for those water treatment plants are available just like emergency transfer for health is, so that you have a fly-in plane to bring a part to you immediately. If we had legislation that said that, we could start fixing those problems quickly. This legislation tells me we're going to be in court and tied up for years, and you're not going to get clean drinking water for years. We need to change legislation, so we're doing action now. This legislation doesn't do it. It's going to tie us up in court for years across many jurisdictions. I want the water fixed now. Don't you? Yeah. This legislation isn't going to do it. This is just going to tie us up in court.
I'm not sure if there was a direct question in that. I understand.
I've listened to people. I know the issue. I know what water treatment plants are. I've been in that business. We can fix this if this legislation did that. It doesn't do it. It ties us up with water commissions, Indigenous and Canadian, provincial and federal governments who are all going to be in court. That doesn't give you clean drinking water and doesn't start it.
Order.
Point of order, Mr. McLeod.
Yeah, Mr. Chairman, I know Martin is excited and is on a roll, but he's not speaking to the mic, so people like me that have hearing issues, it's hard to follow.
I think I was pretty clear. I'm very frustrated. I'm frustrated with legislation that I believe is just going to end up in court, fighting jurisdiction and jurisdiction and jurisdiction. And people, there isn't a process in this legislation that allows for it to move forward, to start building water treatment plants, training staff, having equipment ready, parts delivered. That's what needs to be done. This legislation is just going to set up court action, disputes, years of legal wrangling. I want to see something happen so she can drink clean water out of a tap, so you can wash your kids in a bathtub in your community and not fear that they're going to die from some cancer-related issue. That's what we need to fix.
Thank you very much, Mr. Shields.
Thank you. I'm just going to say something on that, and I'm going to give you both heck, right? Because the Liberals and the Conservatives had a 2013 bill that we had to repeal, and that's why we're here. So we're trying to fix that through this. I know that we have a long way to go, but I think you're both at fault. I'm just going to, and if I can, my knowledge keeper here has been in First Nations working for us for his entire life, and so I'd like to give him the honor and respect for him to say a few words.
Thank you, National Chief. Chair, I've been at this for quite a while, as National Chief says, since 2006, and before that with Chiefs of Ontario on the Walkerton tragedy. During my time at the AFN, we had the opportunity to meet with the former Minister Prentice, bless his soul, and when he was quizzed on what it will take to sort out this problem, and he said it's a matter of money, and that's all it is. It's a matter of money and will of the government to put their will and effort into addressing what you just mentioned, Mr. Shields. Thank you.
Thank you very much, Mr. Shields. Next, we will be going to Ms. Atwin for 2.5 minutes.
Thank you very much, Mr. Chair. And I know we're very limited on time. There's so much that I could say, but I want to hear the voices of Indigenous peoples. I want to hear the voices of our leadership who are here today, and it's amazing to have your testimony. So really quickly, I'll jump right in. National Chief, you've been involved from the very beginning of this bill. How did the AFN approach developing and structuring that engagement process? We've heard a lot of that consultation, some that are feeling left out. Can you speak about what that process looked like?
Absolutely. Thank you for that. I know that we had seen that there was a huge gap in this country, of course, and I know that these discussions aren't always tough to have, but I have to say that I commend many of the technicians, the Assembly of First Nations staff, the chiefs for giving a mandate. Our chiefs come through our assemblies, they tell us what they wish, and we're bringing that forward today in a good way. But certainly they've called on us for many, many years to try and to repeal some of that and to make sure that there's something protecting us. As we see right now, I know that there's so much dumping going on into waters from everybody. Every industry is at fault, right? We're all at fault, each and every one of us. And we don't look at our carbon footprint half the time, myself included. And I know that we have to do something. And so I commend the bureaucrats and many of the people around this table that had committed to trying to work through this. And I ask for you to really seriously consider the amendments from the Assembly of First Nations to this bill, and let's move forward very quickly so that we can get to royal assent. And I think that we all know that there's always a ticking every day, right? Every day we have time to breathe, time to do this work while we're here. And let's make it better so that our children don't have to be sitting here talking about this same issue, and that we're protecting ourselves for the next generations to come. And I think that the way that it is right now, when you see gallons and gallons of raw sewage being dumped into rivers and chemicals being dumped into our rivers and lakes, what are we doing to ourselves? There is no planet B, and there is no extra water somewhere. We have most of it here in our beautiful country. Let's work on it and keep it together. And I'll stay there. I don't know if my knowledge keeper wants to say anything else, but.
Thank you, National Chief. Chair, I'll just be very quick. Just on that, more on the technical issue. The actual process was that we did, with the AFN, we did cross-country engagements in every region. And we met with First Nations technicians and others, and that resulted in documents distilled 26 conceptual points. Well, we heard across the country, and those were distilled into the 6 critical points that were mentioned, that National Chief mentioned at the start, including liability, funding, and source water protection. So that was the process, and we at the time. AFN did their due diligence and got the input from every region. And again, that's true direction from resolution from the Chiefs and Assembly. Thank you.
Thank you very much, Ms. Atwin. À ce moment, on va aller à Monsieur Lemire.
Now we'll go to Mr. Lemire for a minute and a half, so very brief. Thank you, Mr. Chair. Ms. Woodhouse, Grand Chief, would you support banning nuclear waste plant next to the Kehewin, next to the Ottawa River? What's clear is that for First Nations and Anishinaabe, they would not like to see this happen. What's your opinion?
Absolutely. I mean, why would you want to put nuclear waste by source water or by water that we're all going to have to drink and that our grandchildren are going to have to drink from? So absolutely. Thank you.
Parce que c'est le défi pour nous dans l'Est.
Because in Eastern Quebec, especially for us, it's a challenge because, it's similar to the issue of oil in the West. You said that provinces need to negotiate in good faith and need to be clear on protection zones. How can we protect surface water that is used for more than 4 million people, all the while respecting the cultural practices on these lands? Because oftentimes we're letting the industries do what they want and we're not preventing them from accessing this drinking water. And then that has an effect on the quality of this drinking water. And I agree with what witnesses have already said. We don't have enough of a binding nature in this act, and we should be increasing the liability of these companies.
Yeah, it's very frustrating. I hear your consents, like liability and whatnot. You know, the science is not absolute. You know, it's not unstudied. You know, people still eat fish. You know, fish used to be the healthiest food around. You know, and it's kind of hard to tell you the truth with French and whatnot and the earpiece. And yeah, so how do you think about balance? You know, everybody thinks about economics, but the environment is suffering. Even the species at risk, it just seems like it's being ignored, you know. It just seems like economics trumps the environment, you know, and where are we going down the road, you know, like, it's hard, you know, we're frustrated. You know, even about, yeah, we don't even have a seat at the table when we talk about these talks, right? And when you talk about droughts, we're considered others. And that's kind of disrespectful when we're the first peoples of these lands. You know, it's, and we should be involved in the science. You know, you can get water from the air. But when you're going to be dumping, you know, tailings ponds into the rivers, and, you know, we don't think that's safe, you know, and there's it's like, where are we going to go? You know, environment catastrophe, you know, this, the footprint is still getting larger, right?
Chief, I'm very, very sorry. I am going to have
Yeah, I
to-
can go on here for every day, like all day long. You know, this is not enough time. You know, there's room for amendments. You know, I gave my technical supports and everything, but we're here today. We're on good faith. You know, I'm being nice. I'm being kind. But thank you for your time. And I wish we had more time in the future. Merci.
Miigwech.
Beaucoup, Monsieur Lemire.
Thank you, Mr. Lemire.
Go back to Ms. Idlout for just a minute and a half here.
Thank you, and I share your frustration with the lack of time being given to ask questions to our witnesses. I wish we had a better process. I think that we can do a lot better as a committee. My question will be to the legal counsel, Christopher Rapson. Knowing that treaties are not being implemented to their fullest with First Nations, knowing that Canada has ratified multiple international instruments related to the human right to water, can you share us how this government, how do you as a lawyer reconcile the statement of defense in the Shamattawa case? And I'll quote what they said in their statement of defense. Canada does not owe any legal obligations or duties to operate and maintain the plaintiff's water systems regarding the Shamattawa First Nations. Can you respond to that, please?
Yes, absolutely, and thank you for the question. Of course, the Assembly of First Nations would disagree with that legal position taken by Department of Justice lawyers in the Shamattawa case. We support Shamattawa in their class action. And of course, we believe that Canada does have that legal obligation. We believe it's rooted in the Constitution, it's rooted in treaty, and certainly Canada has adopted those instruments of human rights, international human rights. The DOJ position stated in that case does not align with those laws. And this is all the more reason why we need this bill. We need this bill to make clear, without best efforts, because of course First Nations cannot rely on the best efforts of federal governments. We need firm commitments to make it crystal clear to DOJ lawyers and to everyone else that Canada does bear that legal obligation. That's how I would respond.
Thank you very much, Ms. Idlout. Next, for 2.5 minutes, we'll be moving to Mr. Lillo.
Yes. Okay. We do have a little. Thank you, Mr. Chair. I did not know we had another round, so I appreciate the opportunity to ask a couple more questions here. Just think of where I was leaving off. We were speaking of the amendments being put forward, and I appreciate everyone having those discussions. I'll maybe go to Chief John and then Chief Jacko. I'll ask for you both to comment on this about the consultation process and how this has played out. We've heard, I think, some varying things depending on who has been speaking. Obviously, there has been some involvement of First Nations, but as the NDP member also alluded to, the overall consultation has been a very small number of the overall First Nations across the country. So I'm wondering if you could speak to what input in the development process your nation had. Chief John, then Chief Jack. Sorry.
Yeah, it's kind of very frustrating because we said zero input, no consultation on the making of this bill. I share the sentiment of the Chief of Mikisew. You know, when he talks about water, nobody talks about water except my nation. You know, the water is the spirit of my life. And, you know, we have to deal with Alberta, you know. We need a seat at the table. You know, our words are being unheard, you know, like how do we deal with the Alberta government when all our lakes are poisonous? Like when I was young, I'd be able to drink water from everywhere, right? Like Cold Lake is only 2 source water left in Alberta. You know, it's a very pristine lake, and I hope to keep it that way. But we know we need input on this. We need a seat at the table. You know, when they're talking about treaty rights, impacting, because everything comes from water, you know, source water. You know, what the animals going to eat? Biodiversity is changing. You know, where's the mechanic? Where's the, you know, it's just frustrating. You talk about consultation, we had zero input on making of this bill, you know, and it should change. Like we're here today talking about amendments. My technicians already gave input, so, you know, you need a seat at the table. You know, we're already in court. You know, why can't we solve these issues? We should be at the table right from the start when you're talking about water. Like when we're all born, we come from water. Water is life. So things have to be changed. So I'll just leave it at that before you cut me off. Masi.
Mr. Melillo, and our final questioner here, I'll turn the floor over to Mr. Batiste for 2.5 minutes or less.
Thank you, Mr. Chair, and thank you for the testimony, Chiefs and National Chief. It's really good to see you and hear from you today. You know, we've seen throughout the history of Canada a lot of environmental racism in terms of communities, First Nations communities being impacted by corporations, by provincial orders, you know, by a lot of different things. I'm wondering if you could speak a little bit about, I know some of the communities that are impacted by this and how not only this legislation, but the environmental racism legislation that we put forth can help address some of the problems, but also some of the problems that are outstanding.
Oh, geez. Thank you. Thank you for that question, for sure. Well, I think, you know, Bill C-61, we have many areas that the AFN and First Nations across Canada have consistently advocated for, the recognition of the inherent rights over source water. And I think that, you know, we have to work towards that, the minimum binding national standards, of course, a commitment to a funding framework, liability protection for water service employees of First Nation government. So we have lots of these issues that we do need to work through. And you're absolutely right. There's too much, as Chief Jocko had said, too much industry. What trumps that, the environment or industry? And we're not in balance, my friends. We know that. And I think that as we're working through this very important moment in the history of our people, that we get this right, and that we work together, and that we get this right. So you've heard from many of us today, and you've heard from our experts. We've submitted our written submission already, I'm sure. Yeah, so we've submitted our written submission, and I think that we urge all of you to read through that and take into strong consideration AFN's position with our amendments, and let's make this right and get this right once and for all, and move this very quickly. We don't have time to wait, and the planet is waiting for us. First Nations are waiting for clean drinking water every single day, and that's unacceptable. So I urge you all to, let's get down to business, and I look to the staff in the back. Thank you for your commitment as well, and let's get this right, and let's get this to royal assent with the amendment. Thank you.
Thank you very much, Mr. Batiste, and that will conclude our first panel. I want to
There's one last comment, and it's there's a parallel process going on in the Environment Committee, and that's the Canada Water Agency and the modernization of the Canada Water Act. Those go hand in hand with the development of this water legislation. It has a direct impact on what comes out of those, the health of the fresh waters is going to be addressed in the protection zones issue. So those go really hand in hand with each other. So thank you.
thank you very much
Hello.
for that clarification.
I just want to add, thank you all for acknowledging our loss in Manitoba with the passing of late Grand Chief Kathy Merrick, and that she has been very supportive of what we are doing in the way of protecting our waters. I just want to add also that in 2008, AMC had brought a resolution in Canada's proposed drinking water legislation, and I want to be able to send that to the committee and take a look at it, because this has been a concern for quite some time. I've been chief since 2006, and the water situation has been the same, if not has not changed at all, and which is reason why we are here and trying to protect our First Nations. And thank you for listening.
Thank you very much, Chief Kennedy, and I just want to thank all of our witnesses. Of course, we could certainly spend another few hours here, and I really appreciate your time and your input and the briefs that you've submitted in advance. It's certainly going to enrich the study of this legislation and the amendments that I'm sure will be coming down the road. So I just want to thank you again, and we're going to briefly suspend before we move to our next panel. Grateful for our second panel and our great witnesses we'll have here today, including the Honourable Patty Haiju, Canada's Minister of Indigenous Services, and she's also flanked with department officials, including Gina Wilson, Paula Haddon-Jokio, Nelson Barbosa, and Douglas Fairburn. So with that, we're going to jump right into it here. Minister, we'll hand the floor over to you to deliver 5 minutes or less of opening remarks.
Well, thank you very much, Mr. Chair. And I will be able to stay slightly longer than originally because of the delay in the start time, but I think we have a hard stop at 1:45. So really do want to have a fulsome conversation here. And I'm really glad that the committee has listened to so many witnesses over the study of this legislation. It's so important that we respect the voices of First Nations, and the diversity of those expressions and perspectives is what makes such a fantastic country in my mind. So I'm very happy to join you today on the traditional territory, unceded territory of the Algonquin and Anishinaabe people to discuss Bill C-61, which, as you know, is called the First Nations Clean Water Act. And this bill, as you've heard through witnesses, reflects an immense amount of work, of collaboration, knowledge sharing, and real heart from First Nations partners. It really is their work and their contributions and their leadership that have brought us to this point today. The day Bill C-61 was introduced, Chief Erica Bowden of Cowessess First Nation said, "I believe today is historic, not only because the bill has been introduced, but because it's the start of the day where our children will be born with the regulations that are needed. As the bill moves through the parliamentary process, it's now our responsibility as parliamentarians to treat this bill with the respect and the urgency that it deserves." I agree with everyone that it is unacceptable that there are First Nations communities that do not have safe and clean drinking water, and that's what led to the promise to end long-term drinking water advisories that was made in 2015, and we have made significant progress. In fact, I'm pleased to share that just yesterday, Fort Severn First Nation lifted their long-term drinking water advisory. That one had been in place since December of 2022. But we will never be out of this cycle of long-term boil water advisories, short-term boil water advisories, if we don't fix the system that allowed for this process to happen in the first place. And that's what the underlying intent behind Bill C-61 is to change the way that we do things in this country so we're not ever in the position that we were in 2015 again. Bill C-61 would establish minimum standards for water services on First Nations lands based on First Nation choice. It would affirm the inherent right of First Nations to self-government with respect to water, supporting First Nations authority, management, maintenance, and protection of their water in, on, and under their lands. It also reinforces the essential role that provinces and territories play. And you've heard many stories through this study of provincial governments, including while I was here listening to other witnesses, provincial governments who have ignored and excluded First Nations when it comes to water rights and resource management. As the federal government, we do have the responsibility to make sure First Nations have the tools they need to ensure that their inherent rights are affirmed and their jurisdiction is respected. In fact, Chief Knowlton said, "You ought to be with us in any battles we're going to have with Alberta. That's federal jurisdiction. Your obligation and fiduciary responsibility of Canada is to protect the First Nations that you have signed treaty with." I know that no provincial or territorial governments chose to appear as part of this study, and it's disappointing because it's actually an opportunity for provinces and territories to work more closely with First Nations partners. But this legislation does provide tools to encourage and support those relationships, and it's a signal of the critical need for this legislation. Bill C-61 requires the Government of Canada to make best efforts in providing adequate and sustainable funding for water services on First Nations lands, and that the services are comparable to those in non-Indigenous communities. The term best efforts sets a high standard to which the Government of Canada is legally accountable to First Nations. Furthermore, the flexibility in the bill also ensures First Nations will determine exactly what resources they need to properly fund and maintain their water systems. The Atlantic First Nations Water Authority said it well. One has to come before the other. We don't know how much money we need until we develop the regulations. And then with those regulations, we can set forward how much money we need and what our long-term strategic vision for that infrastructure would be. Bill C-61 is a reflection of the direct engagement, extensive collaboration, and knowledge sharing with First Nations partners. And you've heard many witnesses talk about how they've contributed to their bill and what they've advocated for inclusion. First Nations partners closely collaborated on this bill, and we've been working with First Nations partners and keeping them up to date. And I hope that this sets a path for the kind of co-development this country could use for many different kinds of legislation. The engagement process didn't end at introduction. We've continued through the work that you're doing in this study, and as I've said from the beginning, we're open to ways that we can make this bill stronger, even stronger, guided by First Nations voices. So Chief Emerita Emily Weedung McInnes asked us, please do not politicize our First Nations access to one of the basic necessities of life. This is a matter that is too important to get caught up in party politics. The legislation that you're considering relates to a subsection of Canadians whose human rights have been ignored for too long. Bill C-61 is a critical step towards making sure future generations in communities like Niskandiga, Tatasquiok, and Curve Lake will never know what it's like to live without reliable and safe drinking water. And by working together, we have an opportunity to make this a reality for thousands and thousands of people. Mr. Chair, I'm happy to answer any questions or share more information about how important this bill is with the committee. Miigwech, Kuyanamak, Marcy, thank you, merci.
Thank you very much, Minister. And with that, we will go right into our first round of questioning from the Conservative Party, Mr. Melillo. You have 6 minutes, and I just want to mention one thing before we start. There has been some issues with the sound, and so just make sure when you're speaking that it gets into the microphone. And we know we've had some members of the committee and also witnesses that have had trouble hearing the questions.
Thank you, Mr. Chair. Am I good to go? Okay. Thank you. Thank you, Minister, for being here. I appreciate your patience with us as we ran over time in the previous panel. And I do also appreciate you acknowledging the work of the committee here, listening to First Nation voices. I think it's been very important, and I do frankly think that we've all been working in pretty good faith to improve this legislation. I do believe, however, that it does feel like we are doing some of the consultation that could have been done prior to the development of this legislation. And Minister, you've claimed this bill to be co-developed, or I believe close to being co-developed was a term that you used. But we have heard from many First Nations that do not feel that their voices have been heard on this. Chief Sheldon Sunshine told the committee that, and this is a quote, Bill C-61 garnered the support of only 100 out of 600 plus First Nations. End quote. The context of that was a discussion around the Assembly of First Nations. We've heard, of course, some amendments being brought forward. We've also heard from some chiefs and community leaders that want to scrap the bill altogether on such an important topic, which I think is a shock to many, but it is the reality of the situation that we are in because of such a lack of consultation. So can you explain, Minister, how that consultation process went and why so many voices have been left out of it?
Well, thank you very much for the question, and I would say that the extensive consultation has been ongoing. In fact, we've had a concerted and direct outreach with Treaty 6, 7, and 8, who do not feel that AFN represents their voices, and we have worked with them, both at the political level, myself, with direct consultations with those chiefs, and with the department having numerous meetings and consultations, listening to ideas from that region to make sure that their thoughts and their perspectives were included. We've historically published online a draft of the legislation and the approach to the legislation so that people could have access all across the country. We've held hundreds of consultations. We've held coast-to-coast tours. The AFN has held coast-to-coast tours, as well as Canada. And I would say that we are continuing to listen, just as you are. We have heard some very strong ideas about how to improve the bill. Those are important, and as I've said publicly in the House and elsewhere, very open to amendments that strengthen the legislation. and we'll continue to listen to partners.
Thank you,
But what
Minister.
we'll
I
also,
appreciate that.
what
Thank
I'll
you,
also
Minister. I do
say,
have
if I can
limited time.
finish
I do
my
have
thought,
limited
Mr.
time.
Chair,
I would
what
like
I'll
to-
also say
Mr.
is
Chair, I
that
would like to
what
take back my
most
time.
chiefs say
I would like to, with
is that
respect,
there
I
is a
would like
gap
to.
now. There is no regulation or protection, and we must
Minister,
move forward on
members,
legislation.
I'm going to pause
Thank you.
for a second here. When there's the crosstalk happening, it makes it very difficult for the interpreters to do their work. And so I just, only one person speaking at a time. And Mr. Melillo, the floor is yours.
Thank you again, Mr. Chair. Minister, I do appreciate the answer, but I'm sure you can also appreciate the limited time we have here in committee. I do want to speak about the number of long-term drinking water advisories. Back earlier this year in the House, when I rose to speak about this issue, there were at the time 28 long-term advisories that were in place. As of the publicly available data, September 28th, there were 33, so obviously an increase. Minister, do you have the number of how many drinking water advisories, long-term drinking water advisories are in place today?
32, right?
32. So, yes, as I mentioned, that number has increased over the course of this year. We have added, unfortunately, from an overall perspective, more drinking water advisories. Can you describe what breakdown has allowed that to happen to the point that advisories are now actually being added?
Well, first of all, I'd like to point out that since 2015, we've lifted 144 long-term boil water advisories. So with all respect to the member, I find it a little ironic that under the previous Conservative government, in fact, complete neglect led to 144 boil water advisories.
Minister, we can talk
But I
about
will
previous
say
governments
that,
forever. You've had 9 years.
I will say that all of the information about where
9
each
years.
boil water advisory is at is publicly available as part of the commitment to transparency on this issue with Canadians. And as you know, hearing from chiefs and council, there are a variety of reasons why a short-term boil water advisory may become a long-term one. And we work with each community to make sure that we have the appropriate solutions presented and in place for communities to eventually get to those lifts.
Thank you, Minister. I'd like to ask about a local example from my district community you know well, Mishkegoguming First Nation. In January 19th, 2024, they had their long-term drinking water advisory lifted, but in May 8th of that year, the community was back under a drinking water advisory again. A complete failure on the part of Indigenous Services Canada to ensure that this nation had been able to maintain their clean drinking water. What happened in that scenario of Mishkegoguming to allow that to happen?
And Minister, just a brief answer, if that's possible.
Absolutely. Well, first of all, there's a premise problem in the way that the question is posed. In fact, it's the chief and council that determines when a lift will be, when a lift is appropriate. And so I think we need to remember that chiefs and council have the self-determination to make those decisions for their communities. But I will say that Mishkegoguming has a new plant. We are working with the community now on the solutions that are creating challenges with the water that new plant is delivering.
Thank you very much, Mr. Melillo. Next, we will move over to Mr. Hanley for 6 minutes.
Thank you very much. Thank you very much, Minister, for appearing, and to all the officials for being here today. A very important day today. We heard from the Grand Chief as part of this meeting, and on the subject of getting to those more perhaps intransigent drinking water advisories. As you say, 144 have been lifted since 2015. Fantastic work. We've come a long way. Progress has slowed, I think, because we are getting into the ones that are more complex, more nuanced, perhaps more technically difficult. But how do you actually see that this bill and implementation will help get through those last and also be enduring to prevent, which is really our aim, to prevent those boil water advisories in the first place?
for the question, and I think I'll sort of answer it in reverse, because I do think that this bill, and you and I both have a background in public health, so prevention is our first love. This bill actually does set the table so that we never go back to a place where communities don't have the appropriate resources financially, the support technically, or the inherent rights to regulate water that have led to so many of these intractable situations. This government has spent in the billions of dollars to lift boil water advisories, building up, which was an amount that built up over years and years of neglect and years of inequitable funding for First Nations infrastructure, including water infrastructure. So one, I think, important piece of this bill is the co-development of funding models. As you know, and as parliamentarians know, the process for which First Nations receive allotments for water provision, water operation, has always been decided by Ottawa, by the finance minister, by the prime minister. And although we've seen tremendous increases in operating expenses, appropriate operating expenses provided to First Nations communities under this government, you could easily see it slipping back under another government. And so what this bill does is it says no longer can this be an arbitrary decision by Canada, but rather it has to be co-developed with First Nations so that they can set the appropriate regulations and then have comfort that they will have long-term sustained funding that will allow for the development of expertise in their communities, that will allow for a certainty for operator salaries, that will allow for the capacity of the community to grow in its own ability to monitor and in some cases design their water operating systems. The number of stories I've heard about communities who have received contracting, contractors that build these plants that then don't resolve the water safety issue is appalling. And what we're trying to do through this legislation, at least in part, is to restore the self-determination to communities to be able to develop their own expertise, in some case build on the existing expertise so that we never return to those situations again.
Thank you. And you did bring up the question of funding, and we have heard some uncertainty about maybe lack of some have expressed lack of definition about funding. You talked about that in your opening remarks, how this will be set up through the regulations. You have to have the steps in place, but on the other hand, I've heard even today, one of the witnesses saying the government needs to get real and address issues in good faith. And so to me, the legislation is part of that getting there. But how would you assure that the funding for First Nation water services is going to be sustainable, stable, needs-based, and will be addressed through the regulations and what comes after?
And I think that is, one key element of this legislation that is, quite frankly, reflects the engagement process and the collaboration of developing this bill, because that issue came up time and time and time again in the initial consultations. How can we trust Canada? Essentially, if you boil it down, that's kind of what First Nations are saying. How can we trust Canada? Canada has not been a good partner to us as First Nations for a very long time. Some would argue ever. And so this legislation attempts to get at that question of trust by creating a mechanism that compels the Government of Canada to work on funding models with First Nations so that we move ourselves away from a colonial approach, a top-down approach from Ottawa, often made by decision makers who in some cases have never stepped foot in the community for which this will deeply impact their members. And this actually changes it. It changes the model of decision-making around funding allocations that includes First Nations voices at the table. You've heard, I'm sure, so many times First Nations witnesses at this table say, in fact, I heard it just as I was waiting from one First Nations chief, we cannot have decisions made behind our backs, whether it's by provinces or territories or the federal government. We need to be in the conversations. And so the co-development legislation...
I want to squeeze one more question in briefly, but it's really completely about co-development. Like, what have you learned about co-development that could be applied to other legislation that we contemplate?
Just a very brief answer.
About that at length, but I would say that at the beginning of this, we had a very different definition, I think, with members that were helping us draft this legislation and think through this legislation of what co-development was. And by the end of it, I think we've learned that co-development starts a lot earlier than you would imagine. So.
Thank you very much, Mr. Hanley. À ce moment, on va aller à Monsieur.
And now we will go to Mr. Lemire for 6 minutes. Thank you, Mr. Chair. My first question will be related to Mike Morris, my Green colleague partner, and he will be working on supply management, so I will let him speak.
Oui, merci. Minister.
Thank you, Sebastien.
What we heard from Chief Hill earlier this week, her words, quote, and then we have Bill C-61, which introduces non-binding legislation that promises, quote, best efforts. This is a slap in the face. No wonder First Nations often turn to the courts to pursue federal accountability for their issues. Her community is one where 70% of households are without reliable, piped drinking water. We also learned from her that while we've been told that consultations began in 2018, no one from Six Nations was consulted until they had their first opportunity to present at this committee just a few days ago. If you're telling us that First Nations have co-developed the bill, why are we hearing such a gap between communities affected, like Six Nations, Chief Hill's community, and what we're hearing from you?
Well, first of all, thank you for coming, and I know this would be very interesting to the party that you represent, and I'm glad you're here to talk about clean water. But I first want to talk about your question about best efforts. And in fact, in 1994, a decision at the Supreme Court of British Columbia, Justice Dorgan determined that best efforts imposed a higher obligation than a reasonable effort. Best efforts means taking in good faith all reasonable steps to achieve the objective, carrying the process to its logical conclusion, and leaving no stone unturned. In fact, many of the participants in developing this legislation acknowledge that best efforts is quite a significant bar for Canada to reach, and that it holds Canada to a high degree of accountability for the sufficiency in funding, which is what best efforts largely refers to in the legislation. In terms of the consultation, and I won't repeat everything I said to MP Malillo, but we have had extensive consultations, and there have been many opportunities, including direct outreach to every First Nation implicated, including opportunities to submit online, including opportunities to participate in consultations. And I can't speak to Chief Hill's particular experience, but I can tell you that we're still open to speaking to chiefs. As you know, we are working through a process of considering amendments as they might arise from this committee, and we will continue to be there to meet with any chief or council that wishes to speak with us.
Merci, Madame la Ministre.
Thank you, Minister. There's a bit of an elephant in the room here. Why is the Minister of Crown Indigenous Relations not the co-founder of this bill with you? Of course, they can delegate responsibility, but when we talk about First Nations rights, it's not appropriate, this current situation. We're talking about respecting treaties, and this is absent here, and this is what First Nations have said over and over again in this committee. So this sends a message that water management for First Nations is simply seen as an administrative issue for your government, despite the fact that this is really an essential issue for First Nations. Why is this the case?
I'll just say that no bill is actually able to be presented in the House of Commons unless it's supported by Cabinet. And as you know, Minister Andan Sangri and I work very closely together, and I have the full support of Cabinet in working on this legislation. Obviously, I wouldn't be here today. But what I will say is that Indigenous Services Canada works extensively with First Nations communities on water and water development. And while Minister Andan Sangri is responsible for working with communities on things like treaty, he and all of our colleagues are responsible for ensuring that the work of First Nations gets done appropriately and in a timely way. And so that responsibility in terms of services does fall under my portfolio. I do have a department full of officials and engineers and technicians and legal experts in this area, while as his department might not. And so we have worked very closely with Minister Andon Sagari. We have worked very closely with other related ministers like the Minister of Environment to make sure that we are aligned in the work that we're doing to protect water in this country.
Ça aurait été néanmoins intéressant.
Nevertheless, it would have been interesting for them to be here to respond to these concerns. For example, what is preventing the government from investing right now to reduce gaps, infrastructure gaps rather, in several communities that we've heard from? And what's preventing the implementation of a stewardship program? Why does it require this controversial bill for us to move forward?
Seem controversial to you, but it's not controversial to the hundreds of people that have worked on it from First Nations. So I would say that what this bill does is it actually provides the certainty for the kind of work that you're referencing. Listen, right now, Canada can arbitrarily decide how much they want to fund a particular water system. Canada can arbitrarily decide that they're going to cut the funding for water operators across this country. Canada can arbitrarily decide, what regulations might be in place. And what First Nations are saying through this legislation is, first of all, respect our self-determination. Second of all, be a true partner. And that's what this legislation actually achieves. Of course, there are opportunities for amendments to make it stronger. You will deliberate on those amendments. I will look forward to your feedback. As I've said publicly, we are open to amendments that strengthen the aim of this bill. But this bill has really two goals. One is to ensure that First Nations never, ever are in the position that they were before 2015, where they were at the whim of a federal government that did not prioritize their rights to clean drinking water. And two, set a framework where First Nations have the tools they need for full self-determination over protecting their water sources and their water systems. And I can't imagine a way forward that doesn't include those two elements.
Merci beaucoup, Monsieur Lemire. And next, we will go to Ms. Idlout for 6 minutes.
Thank you, Chair. I must start with shaming you, Minister Haidu, for your pride in this work. I must shame you for being proud of the investments that you say have improved so much for First Nations, especially knowing how much gaps there are to ensure that First Nations are achieving equal health, equal opportunities for economic development, that First Nations will continue to have to negotiate their jurisdiction over water. I'm quite disappointed in the work that is what is supposed to help First Nations take ownership over water, still limits them. That is supposed to respect First Nations' right to water, jurisdiction, their human rights, that to introduce a bill that is below the standards set, the minimum standards set by the United Nations Declaration on the Rights of Indigenous Peoples. I feel quite strongly that if the federal government were challenged on this bill by failing to meet the duty to consult standard, that the court would find that you failed, especially having learned that only about 31% of First Nations were consulted. On June 12th, I questioned during the Indigenous and Northern Affairs Committee federal bureaucrats regarding how many people had been engaged. They were very reluctant to respond to my question regarding numbers. Bureaucrats Nelson Barbosa and Joanne Wilkinson, I had to pressure them to finally answer me, where they said out of the 634 that would be impacted by this legislation, only about 181 First Nations were engaged. So there are huge concerns. We've heard from Niskandiga, we've heard from Mikisew First Nations, we've heard from Trevor Noah in today's sitting, and as well as Cold Lake First Nations Chief Kelsey Jaco, and so many more who have not been consulted. I'm quite fascinated by your statement this morning, and I quote you, moving away from a colonial approach, end quote, that you see this bill doing that. But we have currently the Shamattawa case in the federal court that had its 3-day hearing, where Scott Farlinger, I'll quote two sentences from the federal lawyers. The first one is some majority and without unnecessary adjectives regarding the Shamattawa First Nations, as well as this second quote. The claimant under Section 7 may have an extreme need, but Canada doesn't deprive you of your interests and stop you from helping yourself. That to me is very much in opposition to your political posturing, saying that this bill will move away from a colonial approach. Meanwhile, First Nations, because of the way that you've introduced this bill, will be required to consult and negotiate with municipalities, with provinces and territories regarding source water protection, regarding protection zones. And I wonder if you could answer for us how you reconcile that difference, that First Nations, if you respect their right to self-determination so much, why did you introduce that kind of legislation that requires them to have vague notions of what self-determination would look like for them?
Your perspectives, MP Idlout, and I would say on your comment around shame, it will be all of our shame if we don't transform how we do things in this country. And that's what this bill is attempting to do, to transform how we create legislation that deeply affects First Nations people, to transform how we have relationships that are open and that are inclusive and that are evolving to include First Nations voices. And that is the work that I am proud to do, actually. I am proud to do this work. It's difficult work, especially when you represent a system of colonialism that has oppressed Indigenous voices for so long, and yet it's such important work. And so I thank all colleagues for having these important conversations with First Nations partners, because you are hearing the reflection of that difficult relationship in the ways that people are expressing themselves to this committee. I will say that on engagement, there are a number of people that have said that in fact they felt fully engaged. In fact, that the engagement was more than the kinds of engagement they've ever had in the past, including, for example, Chief Crowfoot from Siksika, who said, for the first time ever, we've had opportunities to review and comment on draft legislation. And he said also, although we had to fight hard, Canada responded with critically important changes to the bill. Don't forget,
Minister,
the bill you're studying is
I'm
dramatically
afraid I'm gonna have
different
to
than
ask you to wrap it up.
the first draft.
Thank you very much, Ms. Idlout. With that, we're going to move it into the second round of questioning, and for 5 minutes, I will turn the floor over to Mr. Schmale.
Thank you very much, Chair, and thank you, Minister, for being here. Minister, according to your website, the primary reasons for drinking water advisories in First Nations communities are disinfection at 32%, equipment at 30%, microbiological quality at 18%, and source water quality was 6% of the reasons why drinking water advisories were issued. So given the fact that around 80% of the advisories have something to do with equipment, availability to access parts for repairs, training in community. How come this legislation kind of leaves out that part where we could have a rapid response team similar to a health emergency team that can fly into a community, that can be there with a part, that can repair with the assistance of those on the ground the malfunctioning equipment? This legislation completely leaves out the majority of the reasons why drinking water advisories are in place.
Thank you very much, MP Schmale. And in fact, this legislation will create a framework for exactly that kind of work. But I do want to speak to what already happens in some of those scenarios. So I'll turn to Nelson Barbosa.
Thank you for the question. I would to go back to Bill C-61, I would point to some of the language around substantive equality and comparable services to the question around availability of parts. In some cases, it's not just removing one small artifact or one small piece of equipment. It's about large-scale replacement or expansions of systems. So when we're talking about critical failures of important pieces of work, it's not so much as getting a team of engineers in there. It's about providing long-term solutions and to long-term problems. That's
okay. No, I appreciate that. But given the fact that we have municipalities across the country that are able to quickly deal with this, the fact that you mentioned that this was a framework to develop this process, but the information is here telling, I think, anyone who reads it exactly what the issue is. Again, if we know what the problem is and we can address it quicker by maybe putting this, instead of a framework, having, I guess, action in place to deal with this issue, wouldn't that be a quicker way of addressing the problem rather than this long process dealing with all this other important stuff? But let's get this fixed now rather than potentially spending more in court.
Well, I would agree with you that urgency is paramount, and that's why every community does have a plan. Every community, you can track online what each community's challenges are and where they're at. You know, some of the communities are, in a place where the chief and council is working to have confidence in the lift. Some of the communities are in a place of fixing deficiencies. I will also point out that in many cases, communities, and I would say this is a big difference between the majority of municipalities and First Nations. In many cases, communities are extremely removed from the ability to, for example, transport people and equipment very quickly. And so those challenges get in the way of the work. And so I would just say that
I don't disagree
that's
with
the
those
work
challenges.
that we must continue. But this bill prevents the...
But there are options, kind of like the health. When there's a health emergency, there's the ability to get someone out quickly.
Which is why the Atlantic Water Authority model is fantastic, which is why we work closely with partners like Aqua in Ontario, the Ontario Clean Water Agency, to provide relief for operators, to provide training for operators. There are communities that have, for example, no trained operator. I've spoken to some of those communities. It's not just a matter of offering training dollars, which the Government of Canada has, but there has to be someone in the community that wants to be a water operator. I'm sure you can appreciate it. It isn't something you can force on someone. And being a water operator, I will say, having spoken to hundreds of operators across the country, is a high-stress position. Oftentimes you're working alone. You are responsible for the clean water for your entire community, and many times operators are exhausted. So we also have supports for communities that are operating maybe with just only one trained operator to provide relief for those communities.
Sorry. We spoke earlier, and it was mentioned about best practices, and I appreciate why it's in the legislation. And given that we are talking about healthcare, I also note that when we're talking about Jordan's principle, the ability for an answer to be given by your department continues to decrease. We're down 19% since the year before to meet that 12-hour deadline. Given the fact that your department isn't meeting, I guess, its stated goals, and then we're again developing more frameworks and that type of thing. Should people have confidence that best practices is strong enough?
So just a very brief answer.
Well, it's
for
not
Representative.
best practices, it's best efforts. And
Best
it's in,
efforts, sorry,
it's in
same thing.
relationship to money and funding. So it's actually completely different. It's not the Government of Canada providing services or administrating Jordan's principle. It's about the commitment of the federal government to ensure that adequacy of funding is there so communities can actually have what they need to implement their own regulations.
Thank you very much, Mr. Schmill. Next, we will move over to Ms. Atwin for 5 minutes.
Thank you very much, Mr. Chair, and thank you so much, Minister and officials, for being with us again today. And I just want to start with, again, reminding Canadians and our committee, how we got here. Chronic underfunding, discrimination, oppression in our system, a bill that was previously inadequate, that didn't respond to the needs of Indigenous communities across the country, and currently no enforceable standards right now for clean drinking water and wastewater protections for communities. And so I think it's disrespectful to the work of Indigenous peoples and voices across this country to not acknowledge the progress that we've made. Of course there are still gaps. Of course it's still inadequate. We have to keep working and fighting. But I think if we don't acknowledge how far we've come, it puts that better future in jeopardy. So I just wanted to preface my comments this morning with that. And Minister, really, we've heard from incredible voices. The testimony at this committee is it's such an honor to be a part of. And we've heard concerns. We have heard amendments that have been brought forward. We've heard perhaps also misunderstandings with how the bill will work in application for communities as they move forward. And so I'd really just like to go through some of those concerns quickly. A big one that we're hearing is the idea that Bill C-61 removes any responsibility from the federal government for ensuring this water protection moving forward. Can you speak to that?
And again, I just want to acknowledge that deep distrust of the federal government by First Nations is not unexpected. And in fact, we should all understand that it's a byproduct of colonialism. And so that's what this bill is trying to do, is to change the way that we create legislation and that we change the way that we decide, for example, on funding models to be inclusive of First Nations voices. This could be a path for the country. I hope it is a path for the country in bringing First Nations voices into all of the legislation that we debate in this House, because in fact they are an important partner in the work of building this country and protecting our beautiful natural resources. So thank you for the question. I would just say that what this bill does is it does remove an arbitrariness of funding from the federal government. Now, that's a strange thing to say as a Minister of the Crown, right? I'm sitting here as a Minister of the Crown representing the federal government, and yet I'm advocating for a framework that says no longer can Canada arbitrarily decide, regardless of need, regardless of actual facts, science, figures, what First Nations should receive to operate their systems fairly in a silo alone. But rather that the federal government must work with First Nations to co-develop funding models that will help them achieve their own regulations that must meet or beat, by the way, provincial standards. So that First Nations will have standards of water quality like everyone else in this country and the fiscal firepower to be able to achieve that. This is revolutionary. We've not done this in this country. And to be here saying to you that the Government of Canada commits through this legislation to do so should give you pride as members of Parliament, because it is the first time that the Government of Canada has ever proposed something like this.
And then my time is running out, but another piece that we've heard is the idea that, as the minister, you'd have this veto power, or you'd have this extraordinary opportunity in the end, once this bill potentially is passed, to make decisions without consulting Indigenous communities. Can you speak to that concern?
Nowhere in the bill does that power exist. In fact, what it does is it distributes power fairly and equitably amongst First Nations partners, the federal government, and provinces and territories who will be asked to come to the table with First Nations and the federal government to do a better job in protecting water for all their citizens. There's an opportunity in this for all of the provinces and territories, and I'm sure you've heard, in fact, one of the witnesses that was on just before me talked about how if we don't protect our water, we will not have life. That sounds so dramatic, and yet the more I've worked on this bill and the more I've listened to elders and First Nations, it is fundamentally true. So this legislation actually empowers all of us to do a better job taking care of the most essential, precious resource of life. Thank you.
Okay. Thank you very much, Ms. Atwin. À ce moment, on va aller à Monsieur Lemire.
We'll now go to Mr. Lemire for 2.5 minutes. Thank you, Mr. Chair. Minister, nothing prevents you from establishing regulations to guide oil companies and nuclear companies, rather, in the way that they're using water and disposing of their waste. What specific role does Environment Canada, Transport Canada, Natural Resources Canada, and Health?
What's very exciting about this legislation, merci pour la question, c'est très important pour moi.
Thank you for the question. This is very important to me, because there are First Nations that are living with the effects of these companies' pollution. A variety of pollutants, such as the Kehewin Cree.
Situation maintenant, parce que leur territoire est peut-être
Because their land, their water is contaminated, and people in this community eat the animals on this land.
And the work that I'm doing right now is in sync with the work that Environment Canada is doing on, for example, the first updating the Canada Water Act and the Water Commission. We have to work better to protect people from the effects of contaminants. In Southern Ontario, Minister Guilbeault, as you know, used his orders as the Minister of Environment to pause the production of pollutants from a chemical in Sarnia that was polluting the air with an invisible, scentless chemical that nonetheless is a carcinogen. Worked very closely with the First Nation. The company, as you may have read, was not too thrilled about having to shut down business while they put on better filters and scrubs. And the chief from that community told me, we live in Chemical Valley. We know this industry is important to the economy. Many of our members work in this industry, but it still doesn't mean that we're okay living with practices that are poisoning our members.
Je me permets une autre question complémentaire avec votre réponse.
Another related question. Would you support a ban on building a nuclear waste facility along the Ottawa River, the Kehewin River? This is, of course, a big concern for First Nations. The Anishinaabe, Grand Chief Woodhouse, has stated her concerns on this.
Dis ça maintenant, parce que je ne suis pas.
I can't answer that right now. I'm not a scientist, so I do not have the data. This is far too general for me to be able to give you a yes or no answer for the time being. Thank you very much, Mr. Lemire.
We're going to go to our final questioner of the panel and of the meeting today. Ms. Idlout, you have the floor for 2.5 minutes.
Thank you, Chair. I just wanted to remind the committee, based on the minister's responses regarding removing the arbitrariness of what the federal government can do, that kind of statement ignores legal obligations that the federal government has towards First Nations and ignores important constitutional principles like the honor of the Crown, the fiduciary duty that the federal government has, that they are supposed to act in good faith, and to remind the committee that there is a Supreme Court decision, judgment of Haida Nation, where I quote, "In all its dealings with Aboriginal peoples, from the assertion of sovereignty to the resolution of claims and the implementation of treaties, the Crown must act honorably." This does not prevent the federal government from funding, from introducing laws, that respect their relationship with First Nations. So to posture to us that this would eliminate that arbitrariness, I think disregards that important relationship with First Nations. It disregards the importance of reconciliation that this government must exercise with First Nations rather than refusing to act towards reconciliation. We need to be making sure that as a committee that we've heard from those who have been ignored. Only 31% we were told by bureaucrats were engaged in this so-called co-developed legislation. I do take this opportunity to make sure that we understand, based on what we've heard, that I do recall as well that there have been numerous submissions from First Nations. The Indigenous and Northern Affairs Committee had received my motion on October 4. I would like to submit my motion that the committee direct the analyst to prepare a summary document of correspondence and briefs submitted, including recommended amendments and a summary of issues related to Bill C-61, First Nations Clean Water Act, especially given that we were told this morning by the Assembly of First Nations that they had submitted their briefs, but I've looked through my inbox and I haven't seen any of that correspondence or their submissions.
Thank you very much, Ms. Idloat. So my understanding, you've already submitted and circulated this motion, I believe, last week. So is it just so I have things correctly, are you moving the motion at this moment?
Yes, I am.
Okay, well, with that, we can move to debate on this motion if there is any debate. I can't imagine that. It doesn't seem like there is. So in the absence of that, will this motion carry? Okay, motion carried. So thank you very much, Ms. Idlout. The analysts will be able to follow up on that request thereafter. And at this moment, I'll just ask the committee, is it the will of the committee that we adjourn? Well, before we do that, I just want to thank Minister Haiju and officials for being here today and for providing testimony for the study, and meeting adjourned.